Hello everyone, this is Brian Ka with another video to help you pass the California baby bar and the bar exam. So we're going to continue with another Remedies past essay question here. This is from February of 2015, question 4. So before we begin, by now you should know that I am a person who likes to read the call of the question first before approaching the fact pattern. In this particular scenario, we have two-part call of the questions. The first part says, what equitable remedies can Belle reasonably seek to obtain parcel A? So let's write down here equitable remedies for Belle, right? Number 2 says, what legal remedies can Belle reasonably seek if she cannot obtain parcel 1? So it's a two-part question. The first part, equitable remedies. The second part is legal remedies, right? So to put this in layman's terms, they're asking uh, whether you can argue for things like specific performance, TRO, temporary restraining order, whether you can argue for a preliminary injunction, maybe a permanent injunction, and so forth. For legal remedies, they're asking you if you can try to recover any money. So you would be going into theories like expectation damages, um, compensatory damages, maybe consequential if it applies. We also have incidentals, reliance, and punitive, restitution, and so forth. So to do these questions, you have to memorize, first of all, the types of equitable remedies there are, and let's just go through them in our heads. First is TRO. Second would be preliminary injunction. Third would be permanent injunction, right? In some cases, you may have to argue for like replevin, for possessory interest or ejectment. Um, Also, we have things like um, specific performance. And as you know, we also have things like, you know, constructive trust, equitable lien. So number one is asking, can you analyze using equitable remedies only? It's not asking you for any legal damages, meaning you're not supposed to analyze number one using things like expectation damages, basically a figure, money figure, which they're trying to let you know that you should analyze that as number two and use these concepts for number one. So with that in mind, let's read the fact pattern and see how we're going to approach this question. Also, there are things like rescission. That's another one. And sometimes there are situations where you may have to argue for reformation, to change the contract to um, to go with the original intent of the parties. Courts may sometimes do that, right? So with that in mind, again, let's just try to read the question and see where we're headed. So here, Steve owned two adjoining improved tracts of land, parcels 1 and 2 near a lake. So since we understand where we're headed, let me just erase this and draw a picture of what they're trying to say. So here, we're talking about parcels 1 and 2. Now, it's near a lake. Parcel 1 is bordered, Parcel 1 bordered the lake. So let's just imagine that this is the lake, right? Since they said parcel 1, let's just do this. Okay. And was parcel 2 bordered parcel 1 and was adjacent to an access road. So it's adjacent to an access road. So probably looks like this, right? That's the road. Now, Steve decided to sell parcel 1. This is the land that he's trying to sell, Steve. To Belle, right? To Belle. So Belle is trying to buy this parcel of land. Belle admired 500-year-old oak trees on parcel 1 as well as its lakefront location. So in parcel 1, there are 5, let's say 2, 3, 4, 5. It comes with the land, but I guess it's mature and worth, not sure about what it's worth monetarily, but I guess she has a personal taste in which she, really enjoys these mature trees on this parcel. That's why she's buying it. So in February, Stephen Bell executed a contract for the sale of parcel 1. So February 1, Steve and Bell enter into a contract. Pretty straightforward. Right here already tells us that, we're not going to uh, analyze whether there was an acceptance offer or consideration. This question is not focusing on um, whether you should analyze, if there was a contract. They're telling you that they entered into a valid contract. We don't have to argue that. Just accept it as fact. Now, the contract was for how much? $400,000. Right? They entered into a contract worth $400,000 for this parcel of land and with 5 mature trees. Now we have that. Let's move on. So in addition, The contract stated that Belle was to have an easement across Parcel 2 so that she could come and go on the access road. So this is the access road, and this is the parcel that she's purchasing, the access road. So I'm guessing the easement probably runs like this. Easement, right? Right to use uh, this part of land for a particular purpose, right? But we're not getting into easements here. This is not a property law question. This is straight up asking you for remedies. Um, so moving on. So they have this easement agreement that she could come and go on the access road to use this road. Although the access road was named Lake Drive, this is called Lake Drive. Steve and Belle mistakenly believed that it was named Top Road. So this is Lake Drive Road, but there was a mistake. It seems like a mutual mistake because they're saying here that Steve and Belle mistakenly believed that it was named Top Road. So it was mutual mistake, you know, Top Road. But it's Lake Drive Road, right? So which happened to be the name of another road nearby. So this is Lake Drive Road. They believe that this was Top Road, but Top Road is actually, let's say, here. This is Top Road. Okay. Now, the contract referred to the access easement as extending across Parcel 2 to Top Road. So this easement was supposed to lead here, but they both mistakenly thought that this was Top Road, when in fact this is Lake Drive Road. So obviously, we're going to have to talk about mutual mistake in this case. They're basically telling you all over the facts that this is a mutual mistake, not a unilateral mistake in which one person or party had a reason to know of the mistake, right? So that the contract referring to the access easement as extending across to Top Road, which would not have been any use for Belle. So, you know, a road leading here would not be useful for Belle, right? That's material to the terms of the contract, what she was bargaining for. That's clear. The contract specified a conveyance date of April 1st. Okay, so they enter into a contract on February 1st and conveyance on April 1st. Okay. Later in February, this is where it gets interesting. Steve was approached by Tim, who offered Steve $550,000 for Parcel 1. So this guy Tim comes along and offers 550. Now, Steve decided to breach his contract with Belle and agreed to convey Parcel 1 to Tim. So they had a valid contract right here, $400,000 on February 1st, conveyance on April 1st. He decides to breach this because this was paying $150,000 more, right? Despite Belle's insistence that Steve honor his contract, he told her that he was going ahead with the conveyance to Tim in mid-April and added, besides, our contract is no good because the wrong road was named. Okay. In March, Belle learned that in April, Steve was going to cut down the 100-year-old oak trees on Parcel 1 to better the view of the lake from Parcel 2. Okay, so this guy, Steve, wants to cut down these trees on top of breaching this contract he had with Belle for $400,000. And the question is asking, what equitable remedies can you argue for Belle, right? And what legal remedies can you argue for Belle? Okay, so that's pretty straightforward. So the first one, I would say, um, would be Reformation. And the reason why I would argue Reformation is because in this case, Belle is not trying to rescind this contract. She wants Steve to honor this $400,000 contract. Um, this is the contract that he breached in favor of $550,000. And the reasoning behind that is because he said, besides, our contract is no good because the wrong road was named, right? So, wrong road was named, and he believes that because this term here, Lake Drive Road, the mutual mistake, in which both parties thought that it was Lake Top Road, this mistake he believes will um, rescind uh, rescind the contract. Basically, that the contract was not a complete agreement. That's what he's arguing for. So under Reformation, the in order for us to argue Reformation, there's got to be grounds for Reformation, right? But first, Reformation is basically asking the court to um, draw up another contract which um, better uh, delineates each party's original intent, right? And in order for Reformation to be valid, you have to establish that there is a ground for Reformation. And one of the grounds for Reformation is mutual mistake. Now, when we talk about mutual mistake, it's when both parties um, basically assume that the mistake was the basic assumption of the contract uh, in which the mistake was material, and both parties relied on that material mistake, the basic assumption, right? So I guess for Reformation, we're gonna have to, you know, prove or list the elements because we always want to use IRAC. So before we did mutual mistake, we defined Reformation, right? And for Reformation, you got to have grounds for Reformation, and that is why we're getting into mutual mistake because that is one of the grounds for Reformation. And to prove mutual mistake, uh, mistaken as to basic assumption, material, right? Um, and reliance, right? So if we can prove that there was a mutual mistake, um, we're gonna be able to ask the court to reform this contract to better reflect the intent of both parties. That's why we're doing it now, because um, Steve argument that mistake will make K invalid. Right? That's Steve's argument that we both had a mistake as to the basic assumption of the contract, which was material, and both parties relied on it. So this makes the contract invalid. But that is false because as long as there's grounds for rescission, which is mutual mistake, and there are no defenses, then in this case, Belle will argue that this contract calls for a reformation, and in the end, over Steve's argument that this contract is invalid, Belle's argument will prevail, right? And obviously, to write this essay, I would, plug in more facts using um, the fact pattern here, and trying to argue both sides whenever I can. But in the end, under Reformation theory, we can argue mutual mistake and go through the rules, and then under Steve's argument, you know say what he wants to argue. But on the other hand, we're gonna say Bell is gonna argue this, and that is probably a better argument. Therefore, we have to always conclude saying Bell will probably be able to ask the court to reform this contract so that the original intent of the parties, which was that this road and the easement will be valid, right? Instead of the contract being invalid. So that is one of the equitable remedies that we can seek on behalf of Bell. Another thing that comes to my mind is TRO, which is temporary restraining order. Now, when we talk about temporary restraining order, you have to argue that our client will suffer irreparable harm. Also, have to say the equity dictates that um, that our client will most likely prevail on this merit. We're going to have to prove to the court that this is not some bunk case, because there was a contract and the other party breached. Equity demands that our client will probably prevail on this uh, temporary restraining order argument. And finally, no defenses. They may try to argue that it was unclean hands, that maybe Belle had some kind of fault. She was at fault, so this shouldn't be granted. But a lot of times, or all the time, TRO doesn't have to be done with notice. This important thing here is that it doesn't require notice, no notice, and it can be done ex parte without the other party present. So, using these rules, I would argue that TRO will probably prevail and she'll be able to, until the trial date, she'll probably be able to argue for this restraining order to restrain him from both initiating or completing the sale for $400,000. I mean, $550,000, and at the same time, uh, restrain him from cutting down the valuable trees, because this was already bargained for, and if he cut down these trees, then she'll suffer irreparable harm. And even if he does cut down trees, that's not going to make this invalid, because what Bell is going to argue is to ask for uh, the contract price, $400,000 minus the cost of the mature trees, even though the calculation to figure out how much these trees worth will probably be a little difficult. But if that's possible, that's what she'll do. Now, usually when you talk about temporary restraining order, you also talk about preliminary injunction, right? And preliminary injunction uses the same elements except number four, uh, 1 through 3, but 4, you have to give notice to the other party. So here, I think the argument will be very similar, but this is prior to the trial, and this usually deals with uh, what happens during trial to um, restrain the other party from in, completing this transaction with Tim for $550,000 until uh, the gavel strikes and judge gives a final ruling. You use preliminary injunction to stop Steve from completing the real estate transaction with Tim. So that is another um, equitable remedy that we should definitely discuss. Um, and finally, the real argument here, the best argument here would be for Belle to seek specific performance because there was a contract, certain plus definite terms, legal damages, inadequate, mutuality, feasibility, and no defenses. So we want the court to order Steve to complete this contract instead of breaching it. In order for us to do that, we have to prove that there was a contract. Obviously, we talked about here that they entered into a valid contract. So this is satisfied. The contract was certain and definite, even though we don't know the exact terms. The facts told us that it was a valid contract. So we have to assume that it was certain and definite, especially for it being a real estate contract. So we can assume that it was certain and definite. Now, legal damages inadequate. The fact that this is the land is unique, and when the land is unique, unless we want to uh, tell Steve to pay back the deposit. I'm not sure whether Belle paid $400,000 in cash. Maybe she paid $100,000 in cash. Maybe she financed the rest. We don't know because they're not giving us. But you know, this figure, because this land is unique, unless we ask for the deposit back plus any damages, she has an argument for saying that legal damages or money damages in this case is inadequate. Also, we're going to have to talk about mutuality, the hardship of actually completing this, performing this contract for both sides, and it should favor Belle to win mutuality agreement, which means that for uh, for Steve, all he has to do is to back out from this deal and complete this deal, and that is not too hard, right? And even for Belle, the fact that she was ready to complete the sale for $400,000, it means that the mutuality element would be satisfied, right? Whether if it's feasible for the court to oversee this issue, I guess that's arguable. But Steve will argue that overseeing this type of contract is difficult for the court. It's burdensome and not possible. Belle, on the other hand, will probably argue that it is feasible. The court just has to call them up, in a month or two after, a week or two after the completion of this contract on April 1st, and that wouldn't be such a big problem for either party to complete. So here, I would argue that specific performance is very likely, given that all these elements, the argument for Belle, it favors her over whatever argument that Steve is going to make for this case. If anything, the fact that the land is unique, real estate is always considered unique, and he may try to argue that legal damages are adequate here, but we're going to have to see, because legal damages would mean that he would have to give up whatever deposit that Bell made plus any damages. So it may turn out so that he may lose more money if he wanted to truly pursue legal damages. But as far as equitable remedies go, the fact that we discussed these Reformation, TRO, Preliminary Injunction, and specific performance should be adequate. So let's move on to number 2, part 2, and talk about legal damages. And first, most of the times, either for contracts or torts, we talk about compensatory damages or expectation damages, right? We have to make the plaintiff whole, as if the contract has been fully performed, right? And here, the calculation for expectation damages, usually it's going to be deposit in this case, right? Deposit of 400,000 plus what she paid. She paid 400, and this is subtracted from the fair market value, which Steve got at 550. So if you subtract this, that's going to be $150,000, right? So under expectation damages, um, he can argue for this figure on top of the full price of $400,000 if the deposit was made in $400,000 cash. So in the end, Steve will have to pay back Bell $550,000. But we don't know how much deposit she made. So let's just leave at this plus the deposit, right? Unless we can also add reliance damages or other things like incidentals, but we'll see. So in reliance of this contract, the facts don't really tell us that, she spent money to, move her furniture or, did things in reliance of this contract that she ended up suffering monetary damages. We don't know any of that. We don't get that in this fact pattern. So I would argue that there is no reliance as a result of breach. Does she have to spend any money? Incidental? I didn't see any of that. So no incidentals that we're aware of. But if there's money that she had to spend as a result of this breach, then she may argue for incidentals. Another theory that we should argue is restitution. And restitution, as you know, is usually just unjust enrichment, right? And for restitution, there's usually two ways to calculate. First is benefit conferred and increase in value of land, right? In this uh, scenario, under restitution, if he was unjustly enriched by taking 400,000, and because he accepted or breached the 400,000 and accepted $550,000, he was unjustly enriched by 150,000 plus the deposit. So here we get the same figure of 550, assuming that Belle received $400,000 deposit in cash, everything. If she didn't, then it'll just be deposit plus $150,000, which we can't really derive at an exact certain figure, but that's the argument that she can make under restitution also. So depending on which avenue she wants to pursue, either as expectation damages or restitution, um, she can pursue either or, because in the end, the damages will come out to the same amount. And after that, I guess we talked about equitable remedies here. We talked about legal remedies here. So unless you want to talk about like something like defenses for Steve, if you have time, but I don't think you're going to have enough time for that. Maybe you can quickly talk about things like unclean hands. We didn't really see that. It was all Steve's fault for um, breaching this contract, that it was a valid contract, and he's the one that repudiated. And we don't see any evidence of latches. Um, Unreasonable delay, which prejudices uh, the defendant, Steve here, and we didn't see any of that either. So I think that would be good to for this particular essay. And I know that this was maybe like I would say not a 7, but definitely like around like 6.5 ish. Definitely the hardest one we did so far. I think we've done like 4 or 5. And this was a little bit tough because you had to know exactly what equitable remedies apply here. You can't like talk about constructive trust. You're not trying to, uh, take away the money, or you're trying to force him to affirm this contract, and that is done by, first restraining him from completing this deal through TRO and preliminary injunction, making sure that the court will reform the contract to better um, delineate each party's contractual intent, which was that easement will run across here to this road instead of top road, because that was their that was their bargain when they first contracted to when Steve first contracted to sell this land. And we're going to argue specific performance as a final equitable remedy, so that we can tell the court to force him to finalize this contract that they already had at $400,000. And if those trees were cut, then we can sue for the value of those trees, though try to get the figure for those trees won't be too easy. And two, for legal damages, we always talk about expectation damages to place the plaintiff in a position had the contract been fully performed. And usually that is, the fair market value of the house, which was at $550,000, minus how much she paid under the contract, which was $150,000, plus whatever deposit that she made. um, that would be the legal remedies route. We talked about reliance and incidental, which we really couldn't prove because there were not enough facts showing that there were any reliance or incidental damages. But we could also argue under restitution theory that he was unjustly enriched by taking in this deal, breaching this deal, and was unjustly enriched by $150,000. So if she really wanted to pursue under restitution theory, then she would argue for the deposit she made for $400,000 home, plus $150,000 of unjust enrichment that he was able to profit from by breaching this contract. So I think that should be sufficient to get a passing score for this particular essay. Um, I know that it was a little bit complicated, but as long as you outline it, in the first 20 minutes, 25 minutes max, and start writing it, make sure you don't just finish at one. You're going to have to do one and two, legal damages and equitable remedies, in order to get a higher score. So you can't just stop at one for lack of time. You're going to have to, try to finish this essay and make sure to talk about monetary damages also. And with that, I think we were able to do that under 45 minutes. So that's great. Hopefully, in the next video, I can talk more about another, more difficult remedies essay. And if you're one of the students like I was, I'm still learning, struggling to understand remedies. I hope that this video was helpful to you. And with that, I thank you for watching another video on Brian Ka Law, and I hope you have a great rest of your day. Thanks for watching.